So the next one is, that is the major changes in BNSS. The name of this act is the Bharatiya nagrikSurakshaSanhita 2023. It has
So the
replaced
next one is,
that is the major
the
Code
changes
of Criminal Procedure
in BNSS.
1973. The name of this act is the
Section
Bharatiya
2
nagrikSurakshaSanhita
of BNSS
2023 has been expanded to introduce the
It
new
has replaced
definitions,
that is
audio
the
video
major
electronic
changes
means
in
in
BNSS.
1973. Section 2,
The
1
name of this
subclause
act
A,
is the
section
Bharatiya
2
nagrikSurakshaSanhita
of BNSS, that is audio video electronic means,
2023 has been
section 2,
expanded to
1
introduce the
subclause
new
B,
definitions,
that is bail,
that is the
audio
major
section
Code
2,
of
1
Criminal
means
Procedure
clause D,
1973.
bail bond, section 2, 1 E,
2
bond, and
One
section 2,
subclause
1
A is
I,
the
electronic
Bharatiya
communication.
2 of BNSS,
That is audio video
so
electronic
2023
means
has been
section under the
expanded
definition part,
it has
section 2
replaced
of the BNSS,
that is bail, that is the
has been
major
expanded
Code of Criminal
to
Procedure
introduce D,
1973.
bail bond, definition,
Section
1 E,
2
bond, and
One
section 2,
subclause
1
A is
I,
the
electronic
Bharatiya
communication.
2 of BNSS,
That is audio video
so this is
electronic
the
means
has been
section under the
expanded
definition part,
it has
section 2
replaced
of the BNSS.
that is
So the
bail,
major
that is
changes
audio
been
video
expanded
electronic
to
means
introduce new
1973
bail bond,
additions,
definition 2, 1 E,
2
bond. So total
One-
these new additions, the new sections which are added in the BNSS. So one by one we will discuss here. The first new section added in the BNSS, that is section 86, identification and attachment of property of proclaimed person in newly introduced section 86 of the Bharatiya nagrikSurakshaSanhita. A police officer not below the rank of superintendent of police may make a written request to the court to initiate the process of assistance from a court or assistance from an authority in the contracting state outside the India for identification, attachment, and forfeiture of property belonging to a proclaimed person. So this newly section 86, why this section added under the BNSS? So in the case of Nevada Property Private Limited versus State of Maharashtra 2019, so in that case, Honorable Justice Dwivedi ordered that to unseal the premises of a factory which owned by the petitioner, who was accused of engaging in illegal coal trade, which is given under section 102 of the Criminal Procedure Code. So due to the directions given under this case, the new section 86, which added under the BNSS, to initiate the proceedings, to initiate the process of court proceedings, which a contracting state outside the India for any identification, any attachment, and forfeiture of the property which belonging to a proclaimed person. So on the basis of that decision, this newly section 86, which is introduced under the Bharatiya nagrikSurakshaSanhita. Here we will focus only on the sections and why this section inserted under the BNSS. Again, section 105. Section 105, recording of search and seizure through audio, video, electronic means. Why this provision added under the BNSS? Recording of search and seizure through audio, video, electronic means. It means to ensure the use of technology and to bring the accountability in investigation during the search and seizure. A new provision in section 105, which has been added, making the videography of the process of search and seizure, including the preparation of a list of seized items and the signing of it by the witness mandatorily, and such videography may be done on mobile phone also. So this is the very speedily procedure, and the police officer without delay, they shall forward such recording to the district magistrate, sub-divisional magistrate and judicial magistrate first class. So the philosophy behind this section, section 105, why this section is inserted under the Bharatiya nagrikSurakshaSanhita? As per the directions given under the case, that is Parambir Singh versus Baljit Singh, 2021, the Supreme Court cases, page number 184. And again, there is one judgment regarding this section 105. That is Shafi Mohammed versus State of Himachal Pradesh, 2018, Supreme Court cases, page number 311. So this provision gives the statutory recognition to the directions of the Supreme Court in these cases. And the directions which given under these case laws, our legislature to insert the new provision which is regarding the recording of the search and seizure through the audio, video, electronic means. So it has been added, which making the videography of the process and including the preparation of the list, which items which seized by the police officers and signing of it by the witness mandatorily. And this section 105, it also provides that there is no any delay for forwarding such recording to the authorities, that is district magistrate, sub-divisional magistrate and judicial magistrate first class. I hope this is section 105. I understood it. All the participants, all. Next one, the new section which added under the BNSS, that is section 107. Section 107, attachment, forfeiture or restoration of property. This is a new section, the new provision which has been added to enable the police, with the permission of the court, to attach and forfeit any property which obtained as proceeds of crime. For the first time, such provision on attachment, forfeiture and restoration of proceeds of crime has been introduced in the BNSS. This provision will increase the liability on proclaimed criminals, on fugitive criminals, and act as compelling factor for their participation in the proceedings which instituted against them. And for that purpose, this new section 107, which is added under the BNSS. In the earlier old draft in the Criminal Procedure Code, this is not included under the CrPC, this provision. There is no any references. The new provision, which section 107, which added for the first time regarding the attachment, forfeiture or restoration of the property. The next new section which inserted under the BNSS, section 172. Persons bound to conform to lawful directions of police. Section 172, this is a newly inserted section. The power of police to detain or remove any person resisting, refusing, disregarding, etc., to conform to any direction of a police officer is introduced, which warrants production of such person before the magistrate, and in PT cases, release of such person within 24 hours after the incident is past. So any person, whenever the police uses their powers to detaining or to remove any person which the person resisting or refusing to give any answer or not responding towards the police officers, or to disregarding or to conform to any direction of the police officer. So such person, the police officer is introduced, which warrants which production of such person before the magistrate. And in small cases, in the PT offences, release of such person within the 24 hours after the occasion is past. So this is a very essential and important provision which added under the BNSS. Next one, section 336. evidence of public servants, experts, scientific experts, police officers in certain cases. So this section is relating to the evidences of any public servants or any scientific expert or any medical officer or any police officers in certain cases. So to make the criminal proceedings more efficient, Section 336 provides that where any document or a report which prepared by a public servant or any scientific expert or any medical officer which is used as evidence in any inquiry, in any trial or other proceedings, the court shall secure the presence of the successor in office of such public servant or such scientific expert or any medical officer. So this process has also been allowed with the use of audio video electronic means for the purpose of such deposition. In the earlier draft in the criminal procedure code, there is no any provisions regarding the evidences of any experts or evidences regarding the public servants, because there are some incidences which happen due to the death of any public servants or any experts or their retirements or any unavoidable circumstances. So for that, the delaying the procedure, and for that purpose, the newly Section 336, the newly inserted this provision, the court shall secure the presence of successor in office of such servant or such experts or such police officers or any medical officers. And one more important thing is that, and one more benefit which is given under Section 336 is that this procedure regarding their inquiry, trial or other proceedings, this process has allowed with the use of audio video electronic means for the purpose of such depositions in that inquiry, trial or other proceedings. So this is another the important change under the BNSS. Next one is that Section 356. Inquiry, trial or judgment in absentia of proclaimed offender. This is a very important provision because these problems, this procedure, this section which is relating to the fugitive criminals, the wanted criminals, and addressing these problems, a new provision of trial in absentia, it has been included under Section 356 of the BNSS for persons declared as proclaimed offenders. And the process involves the issuance of 2 warrants of arrest within an interval of 30 days. Again, publication of notices in 2 local or national newspapers notification of the commencement of trial to their relatives also, and the affixing of notices regarding the trial's initiation before the commencement of such trial. Further, under the section 356, the trial against the proclaimed offender can only commence after the passage of 90 days from the date of framing the charges. And this provision extends the right to legal representation of the proclaimed offender, with the state appointing an advocate for the absent accused defense. So this innovative framework diverges from the prevailing norm limited to only recording witness testimonies during the trial in absentia. Instead, it involves the entire judicial process. It focuses on the entire judicial process, extending from the presentation of evidence, final judgment, and determination of the punishment. The most important thing under section 356 is that, importantly, should the absconding individual rejoin the proceedings mid-trial, they are entitled to participate and benefit from the due process in their defense. So this comprehensive approach reflects an equitable stance, ensuring the fair treatment throughout the trial process. Again, here I will mention here the most important judgment. And due to this judgment, and due to the directions which are given under the, in the case of Hussain and another versus Union of India, 2017, Supreme Court cases, page number 702. And also in the case of Anant Dixit versus State of Orissa. So this section 356, this provision has been added in view of these directions which given under these landmark judgments. So this is all about section 356. The next one, section 398, Witness Protection Scheme. This is the newly section, the new provision which inserted under the BNSS, Witness Protection Scheme. Section 398 this section mandates the preparation and notification of a witness protection scheme by every state government. A witness protection scheme, it serves as a safeguarding mechanism, fostering an environment where witnesses can contribute to the legal process devoid of fear or duress, and the necessity for a comprehensive witness protection scheme, which has been underscored by the Malimat Committee and various law commission reports, including the 40th report, 154th report, 172nd report, 178th report, and finally 198th report. So section 398 Witness Protection Scheme. This section why inserted under the BNSS because of the landmark judgment which given in Mahindra Chawla versus Union of India. The Witness Protection Scheme, this 2018 draft was approved by the Supreme Court in the Mahindra Chawla case. After that, in 2023, there is another landmark judgment regarding the Witness Protection Scheme, Sunil Sain versus State of Haryana, 2023. So in that case, irrespective of the fact that states are following witness protection scheme or not, the presiding officers, director of prosecution, which are the duty, which is the binding duty, they are bound to follow the directions given in the Mahindra Chawla case. And due to the directions which given under the Sunil Sen versus State of Haryana, the newly section 398, which inserted under the BNSS, which is the most important and the very important scheme, the very important issue which faced by the people, that is the parties, witness protection scheme. So witnesses, they can contribute to the legal process without any fear or without any duress. So for that purpose, section 398, this section inserted under the BNSS. Again, section 472. This is the newly section. Mercy petition in death sentence cases. A new provision for time-bound disposal of mercy petitions filed before the President and the Governor has been made in section 472 of the BNSS. This provision prescribes a time frame requiring such petitions to be filed within 30 days before the Governor and within 60 days before the President. And the Superintendent of the jail is now entrusted with the responsibility of informing the convicts about the confirmation of their death sentence or the dismissal of their appeal or review of a special leave appeal. Any information regarding that matter, it is the responsibility of the Superintendent of the jail to inform about that case to the convict. Additionally, under section 472, the jail superintendent is mandated to ensure that every convict, especially in cases involving the multiple convicts, submits their mercy petition within 60 days. And in situations where no other petitions are received from the remaining convicts, then the jail superintendent is required to forward their names, their addresses, and case records to the central or state government for the consideration alongside the mercy petition filed. Further, Section 472 is also stated that the central government is to give its recommendations to the President within 60 days, commencing from the date of receiving comments from the state government and records from the jail superintendent also. And it has also been provided that no appeal shall lie in any court against the order of the President, which made under Article 72 of the Indian Constitution. It shall be the final and not to be inquired into by any court. This comprehensive provision streamlines and ensures timely and equitable consideration of mercy petitions. Again, this section 472, which is added under the BNSS, for the directions given under the case, in the case of Shatrugna Chauhan versus Union of India, 2014. In that case, the court held that mercy petition which pending for a long time, this is the violation of Article 21 of Indian Constitution. So we can convert it into life imprisonment. There are various case laws, various judgments which given by the Supreme Court regarding these mercy petitions, delay in mercy petitions. And for that purpose, section 472, this new section added under the BNSS. And lastly, section 530. This section added under the BNSS, trial and proceedings to be held in electronic mode. This section, which provides that all trials, inquiries, and the proceedings may be made compatible with the technologies and held in electronic modes by use of electronic communication or through the use of audio video electronic means. So in number of provisions under the BNSS, the audio video electronic means introduced in various provisions. Specifically in section 530, the trials and proceedings and the inquiries which may be held in the electronic mode. So this is all about the new additions under the BNSS. So these sections added under the BNSS and some of the sections which deleted in the BNSS. So these sections which deleted section 2 clause F India, this definition deleted under the BNSS. Already these sections which given under CrPC, there is no any references in the BNSS. Totally these all sections deleted. Section 2F India, section 2K metropolitan area, leader definition, prescribed definition, metropolitan areas. In some of these sections, there is a term metropolitan areas or assistant session judge. These terms are removed under the BNSS. Then section 10, subordination of assistant session judge. Section 16, 17, 18, 19, these are the, and section 27, these are the hierarchy of the criminal courts. So these sections are deleted. Again, section 144A, power to prohibit carrying arms in procession. Section 153, inspection of weights and measures. Or section 335, metropolitan magistrates judgment. Or section 404, statement by metropolitan magistrate of grounds of his decision to be considered by the High Court. So all these sections deleted from the BNSS. And lastly, we will discuss here some positive changes under the BNSS. Removal of some incentive terms. Several positive changes have been made under the newly enacted BNSS. Removal of some incentive terms. This is the major positive changes. Removal of some incentive terms or clarifying some procedures. The BNSS has replaced many terminologies such as a lunatic person or person of unsound mind, and such references have been replaced with the more incentive terms, the more sensitive terms, that is the having intellectual disability or person with mental illness. Again, some other references which relating to the term, that is assistant session judges, leader, metropolitan area, metropolitan magistrates, or presidency towns of Bombay, Calcutta and Madras. So these references, these terms have been removed from the corresponding sections of the BNSS. Then clarifying some procedures. This is also one of the positive change under the BNSS. A new section, section 356, which has been added for a detailed procedure for conducting by adding a clear explanation regarding section 516 corresponding to section 468 of CrPC. Disputes regarding the computation of period of limitation, which have been finally settled. Another in the new chapter which governing the bail. A new section 479 has been added, which right in the beginning to clarify the scope of certain words in the law. And this section explains the concepts of bail, bail bond, and the bond. Another change is the progressive safeguards or the changes. BNSS has also, it provides the use of forensic science in investigation of crimes. And also the most important section under the BNSS, that is section 349, it provides for the use of it use the fingerprints and voice samples in addition to specimen signatures or handwriting samples. And another change in the BNSS, that is section 230, for supply of copies of documents to the victim or their advocates. So these are the progressive safeguards, and the most important is electronic digital alternatives for existing processes. To achieve the target of Digital India, a new section 532 has been added to the BNSS. It providing for all trials, inquiries, and proceedings, and recording of evidence or examination of parties, their issuance, service, and execution of summons and the warrants, and several other processes can be done electronically. As we earlierly discussed here, some sections which are relating to the electronic or digital alternatives. Section 64 of the BNSS, Section 70, Section 71, electronically serve the summons and its digital communication would also be considered valid. And it expediting the process and or making the processes time bound. This is another change, positive change in the BNSS. Section 336 of the BNSS provides that any document, if prepared by a public servant, please mute your mic. Section 336 of the BNSS, it provides that any document, if prepared by a public servant, any scientific expert, or any investigating officer, he is supposed to depose as evidence in a court. But now, due to the unavoidable circumstances like the death, retirement, or inordinate delay in getting such person, the court can secure the attendance of the successor officer of such person. So these are some positive changes regarding the BNSS. And lastly, I will focus on the criticisms. The most of the changes which brought in by the BNSS, it can be said to be to meet out the basics of the criminal procedural law. But at the same time, some changes introduced by BNSS can be said to be of concern as they do not fit in these basics, such as section 349 of BNSS and under the CrPC section 311A, magistrate may ask any person without a history of arrest to give us samples such as fingerprint, voice sample, or handwriting samples. Earlier, this could not have done unless the person was not arrested in connection with an investigation. It is submitted that this exercise of sample taking should be exercised with great caution and only when it is of almost importance to a trial, this part is missing. It is a lack of scrutiny. This is also one of the criticism. And the vernacular titles of the criminal laws, that is the Bharatiya nagrikSurakshaSanhita, Bharatiya Nyaya Sanhita. So these titles, it violation of Article 348 of the Indian Constitution. Sorry, Article 348 of the Indian Constitution. Article 348, it stated that the language to be used in the Supreme Court and the High Court and for the acts, bills, etc. And some problematic provisions which introduced under the BNSS. So this is all about the comparatively study of the Criminal Procedure Code and the BNSS. I think I focuses on all the major changes under the BNSS 2023. So I will conclude my lecture here. Thank you. Thank you very much.
There was a down, yeah. Thank you, Swati madam. Of course, it was a very comprehensive kind of lecture wherein all the provisions, the major provisions of major changes from CrPC to BNSS have been explained by you in proper detail. I would like to ask the participants if any discussions, any questions are there. Please raise your hand so that and unmute your mic so that we can discuss. Swati madam, you can stop sharing so that.
Okay.
Any participant has raised